Hartley reminds me, I probably also ought to have identified here on page 20. Have a look at lines 25 through to 33.
Yeah, yes, which I have.
Thank you. Then, if we then move to page 22, this for the sake of those listening, we're now at 5:20 a.m. in the morning. So at page 22, have a look at particularly lines 28 through to, on page 23, line 9. And it's that particular part for note where the delegate indicated that he was going to be finishing his shift soon and the case was going to be handed over to another team. Now, that didn't happen, but what also didn't happen was the original agreement to allow Mr. Djokovic until 8:30 was not adhered to. So that's a bit of interesting context. Then it's at this point, so that exchange finishes at 5:22 a.m. You can see that at line 14 of page 23. It's at that point in time, to understand the matter chronologically, that one has to go back to Mr. Djokovic's own affidavit, because now the tape's off. And if we look at paragraph 23 of Mr. Djokovic's affidavit, read paragraph 23 and 24 of Mr. Djokovic's affidavit in their entirety, the substance of which was, while the tape recorder is off, initially approached by two of the delegate's superior officers, given the peculiar advice that it was somehow in his interests not to speak to his lawyers at Tennis Australia and so forth, and that, it was better for him if they just made a decision. And then paragraph 24 concerns the subject of him being, Mr. Djokovic being woken up by the delegate and one of his superiors, presenting to him that it was, quote, better for me if the interview was done right away. And again, consistent with the proposition of putting the pressure on him to just subject himself to the decision being made, rather than obtain the support and the assistance of those who might otherwise have advised him before a decision was made. So that's 23 and 24, which are off record. Then we come back to the transcript, and we're back on page 23 of the transcript. And so now it's 6:07 a.m. And I would invite Your Honour to look at lines 32 to 37 in particular. That's the exchange I think that Your Honour pointed out to me earlier, and that is effectively where it ends. The decision is made shortly thereafter. What clearly emerges from all of that, and what I've really discussed with Your Honour, is that it was abundantly clear throughout that whole process that Mr. Djokovic wanted more time, at least until 8:30, to speak with his advisors, his agent, Tennis Australia, to understand what was going on, to see if there was anything with the assistance of those persons and bodies that might be said in his interests to put against the suggestion that his visa was going to be cancelled. Point 2, that was initially acceded to, and it was agreed that he would be given until at least 8:30. Then, point 3, that agreement was reneged upon. The only basis upon which that 180-degree turn was adopted by the officers, as evidenced in the material, was the entirely spurious suggestion that somehow it was in Mr. Djokovic's interests if they just made a decision and he didn't talk to anyone who might otherwise support him and assist him to make submissions against why they shouldn't cancel his visa, and perhaps the suggestion of the practical concern of the delegate's shift being about to end, which could possibly provide a reasonable basis to make the decision when it was made. Very briefly then, Your Honour, as to law, we've run this point obviously in two different ways, fairness and reasonableness. They're distinct concepts, obviously, although they can cross over in their application. As to fairness, all I wanted to say, Your Honour, is briefly, this is the one point of legal dispute between the parties that I adverted to at the start of my submissions. If I can invite Your Honour to look at the Act, section 124, sub 1, paragraph A. Section 124 is headed.
I am sorry. Reached that point in the case. 124
Yeah. So section 124 has the heading, when decision about visa cancellation may be made. That's part of the partial code of the Natural Justice Hearing Rule.
Yes.
And it says that the minister may cancel a visa at any time after notice is given under 119 and after whichever one of the following happens first. Now, what's emerged is that Mr. Tran, Ms. Wooden and our team are in agreement in regard to legal principles that here B didn't occur and C is inapplicable. C is inapplicable because this was not a time-bound duration process. That's because the delegate exercised power under 121 to invite the response to be given at an interview, which is not a period of time that is bound by a period. So the only issue between the parties, Your Honour, is whether or not by the time that the decision was made, which I think was at 7:29.
Yes, notified at
7:29, notified to Mr. Djokovic at 7:42. I think I made an error about that earlier. So a decision was made at 7:29. The question is, under 124 of the Act, at 7:29, is it the case that the holder had, quote, responded to the notice? And the dispute between Mr. Tran and myself is essentially this. Mr. Tran submits, as he did last night in writing, that respond there can't mean, in effect, complete response. It just means a response. And we say that is obviously not so, and indeed, were it so, it would generate perverse consequences because a visa holder might be, in effect, partway through saying what they want to say about why the ground doesn't exist and why the discretion shouldn't be exercised if the ground does exist. And the minister might say, I've heard enough, you have responded, in part, I'm now going to make a decision. Obviously absurd. The way that Mr. Tran tries to ameliorate that perverse consequence of his interpretation is to say, it's okay because principles of legal reasonableness kick in. And of course, the minister couldn't, or the delegate couldn't, without contravening, would have to adhere to the principles of reasonableness in deciding when the minister thought that the applicant had responded, whether he'd heard enough. The problem with that is it conflates very different concepts of fairness and reasonableness. Mr. Tran's submissions are at pains to point out the very broad decisional freedom that he adverts to the cases speak of when it comes to